Hello, I'm Laura Darcy and I'm a partner in the commercial employment team at BLM. As lockdown restrictions start to ease, you may be thinking about bringing your employees back to work or into the office and looking at ways to reduce costs, but without necessarily reducing the number of employees that you have. You may be looking to change working days or hours or to propose pay cuts. Most employment contracts will not allow you to make these kind of changes without an employee's express agreement. This is because anything to do with pay that is contractual is a fundamental term of an employment contract. So there are three options when it comes to implementing a binding change in employment terms. The first is to get the express agreement of the employee. The second is to impose the change unilaterally and rely on the employee's conduct to establish implied consent to the new terms. And this is what a number of employees did when they were placing their employees on furlough leave. The third is terminating the existing employment contract and offering re-employment on the new terms. This video does not address collective consultation when there are more than 20 employees who are affected by the proposals. The second option is inherently risky. It's not going to be immediately lawful or binding, and it can create uncertainty, especially if employees refuse to recognise the new terms or stand and sue. So perhaps it's one best to avoid. Where the alternative might be redundancy, or if the change is only temporary, then it's going to be relatively straightforward to get the employee's agreement, especially if you transparently explain the rationale for the proposal and respond to any individual concerns that they have. And if you do get their agreement, then it's best to record that in writing. If you cannot quickly reach agreement, then you'll need to formally consult employees about the proposals and warn them that their employment could be terminated if they do not agree. Give them an opportunity to state their case and be heard at a hearing. Consider if you can help them in relation to their particular concerns. For example, if it's financial, you might be able to offer a hardship loan or refer them to an employee assistance programme. If it's more to do with caring responsibilities, then you may be able to speak to them about a flexible working arrangement. If termination is unavoidable, then just remember to immediately offer them new employment on the new terms to give them one final opportunity to agree that. There are some other risks too. For example, you need to be aware of the risk or potential of discrimination claims, and this will be apparent where a proposed contract change will affect large proportions of the workforce that share a protected characteristic. And in connection with the kind of changes we've been talking about today, those characteristics are likely to be sex or disability. The safest thing to do is to seek legal advice at an early stage in the process so that pitfalls can be avoided and to ensure that changes are legally binding and risk is minimised. If you have any further questions or you need specific advice, then we are offering businesses a free half-an-hour telephone or video call to talk you through the steps you need to be taking if you're considering contract changes. To discuss your business's future plans, then speak to one of our team now using the details at the end of this video. Look out for part 6 in our Life After Lockdown series on employment issues in relation to flexible and home working.